Everyone, I'm Jane Scott, and my colleague Rosa Castello and I teach legal writing at St. John's University in Queens, New York. We have a handout also. It's the one with the building blocks graphic on the cover, and that's your cue that we're going to be talking about teaching the building blocks of legal writing. And the first page of the handout gives you the list of building blocks, and you can see that there's nothing innovative about it whatsoever. These are simply the building blocks that we all teach. This is the IRAC package. And we really probably should have called our presentation something slightly different, something like teaching legal writing as a set of building blocks, as a set of essential components. We try to tell our students from the beginning of our first year course that they will, in practice, be writing in a variety of formats, from email to a traditional full-blown office memo, but that every piece of written communication of legal analysis that they produce has to contain these essential components. So we try to build the course around the components rather than around a particular form of document. And although we use this building block metaphor, another useful way of thinking about what we're doing, in my mind, is the image of an accordion. So you can squeeze it all the way in and make a really small sound in which each of these components may consist of nothing more than a couple of sentences. Or you can open it up and make a big elaborate sound in which each of these components is more fully developed. So Rosa's going to tell you how we implement this approach in our course, and then we'll show you one of our lessons on one of the components that we teach at the beginning.
Thanks, Jane. So we approach this class as legal writing is structured writing, and so we conceptualize it as building blocks that you put together to form a whole. And we really want to emphasize the purpose of each of those blocks over the particular form it may take or the particular name you may call it. So we really focus on the purpose and the function, as Lisa and Sarah were both talking about. We began with talking about the different blocks and what purpose they may serve, and we showed them examples of different types of writing, so formal memos, which it's easier to identify the components. They're often labeled, right, issue, conclusion. And then we had drafted up some client letters, emails, and we had them read those through and identify the building blocks, and we talked about the purpose and the content of them. From there, we then, each class took one block individually, and we lectured on it. We showed them examples of it, and we did an in-class exercise in which they had to write that component of the memo. And then for homework, they had to go home and write that component using a different problem that we had given them, the same problem that we used for homework throughout the entire semester. So by the end of the semester, they had literally built block by block a full formal memo in their homework, and which of course they would do for a graded assignment using a different problem. And then we kind of wrapped up by talking about how we can cut down and refashion and reshape the formal memo to serve all different kinds of functions and purposes of legal writing. This is the PowerPoint for the first class that we had, our first building block, which is the issue statement, which we're going to talk about today. We began this class really, and this is our second class of the semester, by talking about how does litigation begin? You know, where does it start? It starts with a client coming to you with a problem. Essentially, they want to maybe sue someone, or they need you to defend them for something. And so what your purpose is to tell them, do they have a claim? Can they sue someone? Or do they have a defense, right? So the issue statement is essentially the question of how or whether the law applies to that client's situation. That's the purpose of the issue statement. And we talked briefly about different types of issue statements and the content that it may have. We gave them some examples as an overview. But our focus is always essentially starting with the purpose of that component. Then we talked a little bit about identifying issues. Not so much, it just tied in well with the class, but, and we said, you're not going to have to identify legal issues in this class, and probably not in your early practice. Someone's going to come to you with a problem and say, can you, find this statute, or do we, this requirement met? So it's not really important, but it was a good way to talk about the difference between broad issues and narrow issues, and how the narrow issues are the requirements or components of the broader question, do you have a claim? So we talked about that. And then we moved into how do we go about writing an issue statement. And so we talk about the purpose first, and we discuss that legal writing can take all different forms, okay? So you can write anything, but you're always answering a question, a legal question. That's what you're doing. So the purpose of your issue statement is always going to be the same, to identify that legal question for yourself, for the reader. Then we talked about the fact that it may take on different names in practice, right? What you call it is not important. And so we talked about what different names you might see so that they would be able to identify it in legal writing that they're reading as examples, and also that they would be able to adapt to calling it something else in practice if that was their function in the form or the convention of their practice that they were in. But still, again, focusing on the fact that it's always going to be the same, for serving the same purpose. Then again, we readdress this idea of narrow and broad issues. So you may see broader questions about whether you can bring a claim, and more narrower focused questions about whether that requirement of a certain claim is met. And we gave them examples of this so that they could understand what they might see. So here's a broad example, right? Does our client have a claim against Mrs. X for libel? And the same with, narrow examples. So this would be a particular requirement for a libel claim. From there, we move on next to the content, which is the important part, what they want to know. How do I go about writing this? What do I include in my issue statement? And here's where we really want to, again, get them into the idea that it doesn't matter what type of practice you do or what form your legal writing takes, you're always going to have a question to answer. And so the most essential component of your issue statement is the question that you're asked to answer. But it can have different components depending on what purpose or function your overall writing is serving. So it may include facts, jurisdiction, source of law, and governing rule. And so we start out with that. And it's the same thing with different styles and formats. It may take on a one sentence, it may take on 3 sentences, it may be written as a question or a statement, and that depends on what type of writing you're doing. And what we like to really emphasize to them here is that no matter what you're asked to do in legal practice, if you're asked to write a letter or an email or a formal memo, you're always going to have your issue statement serving the same purpose, right? Because the essential purpose of the writing itself is always the same, to answer the question. So the issue statement is always the same, and it makes them feel comfortable, maybe a little bit more comfortable, that when they get out there, they will be capable of doing whatever it is they may be asked to do by their supervising attorney. And they like having things tied back into practice. This is what it will be like for you. And so we gave some different examples of this type or style of writing. And we talked about letters and emails and how they could be less formal, not meaning that they shouldn't be written using still the same formal language and having the same content, but the idea that they're not full-blown memos. And we gave examples of what an issue statement might look like in a letter, for example, or an email to a senior attorney who asks you a question. And then, of course, what it might look like in a formal memo. And there's an example from that. And then we talked about, some variations that you may see in formal memos. And finally, what we get to is the content of the issue statement. So other than the most essential component, which is, of course, the question you're asked to answer, we get more into depth into the other components. And once again, when we talk about these other components, the smaller components of the larger component, we start with the purpose. What is the purpose of adding facts to an issue statement? Why might you do that? And so, we tell them about how it adds information. So it serves an informative purpose, and you're telling the supervising attorney, and you're also maybe identifying for yourself what are the critical facts that are going to come up in your analysis. And that's the purpose this serves. So when might you include facts depends on what purpose you're serving in your larger writing, the overall goal of your writing. So we talk about when you might include it, and we talk about how you might include it. And the helpful thing for them always is to give them examples, right? So here's an example of how we might include the facts into a formal issue statement, which has, of course, the most essential component, which is question, and then the facts added. Excuse me. And then we talked about writing it as 2 sentences. So the idea being that we always want our writing to be clear and concise, and sometimes issue statements particularly can get very unwieldy and out of control. So we always want to bring it back to how do we make it clear and concise writing. And then we do the same with jurisdiction and source of law. So what is jurisdiction and source of law? We talk about that, and then we talk about the purpose it serves in the issue statement. Why might you add it to make your issue statement more specific? When might you add it, right? And we talked about the different types of writing that you'll do. Here it is in a formal memo, which is mostly when you would see it used, sometimes in more informal writing, particularly when you're talking about statutory law. And then the same for governing rules. So here's the purpose of it. Again, you're even more informative here, which means that it's less likely to appear in the less formal writing, and giving examples. Now, we're building on the same example, of course, throughout, adding the different components. And then we talk again about the solution of making it into 3 separate sentences so it's not as unwieldy. And then when it's used. And finally, we review all of this for the class before we have them do the in-class exercise, answer any questions that they have. And Jane is going to go over with you the particular exercise that we use for this class and how we went about doing it as an in-class exercise. Yes.
So one of the things we like about this approach is that it enables us to start with the issue and how to write it at the beginning of our semester of first-year legal writing. And we think that's important because legal writing in practice is about answering questions. We always start by stating what the question is that we were asked to answer. But if you try to teach writing a traditional question presented as encountered in a full-blown brief, you're teaching the students to write something very convoluted and formulaic that goes against the grain of one of our most important messages in the course, which is writing for law practice should be straightforward and direct and easy to understand. The one-sentence question presented is none of those things. But it's still important that students realize how important it is that they start their thinking and writing process by stating the issue. So by approaching it this way, we're able to show them, the issue can be nothing more than the ray line in your email. It can be nothing more than a sentence saying, you asked me to answer this question. You can also find it in a full-blown form, incorporating these add-ons, and then it gets very big. But at its most basic, it's simply a question, a statement of the question you were asked to answer. So in our in-class exercise in this class, which you have towards the end of your handout, we have them write the issue statement in several different formats. And you can see them there, the sheet with the lines on it. Rosa and I have found that if you put lines on the page, the students are more likely to write out their answer on those lines. It seems to give them some sort of welcome structure. And we're using in this in-class exercise a problem that the students have worked on or read about in their 2-week intensive legal method course that our law school still teaches them. So they have an Intro to Law course, is now the formal title, but it's the old legal method course that many of you may have had in law school and that I had. And it takes a lot of stuff out of our course, actually, or should, because it's real basic skills of case synthesis, statutory interpretation, how to brief a case, and so on. So we like to think that our students have really learned a lot of that by the time they get to us in the beginning of the 3rd week of their law school experience. So by picking up on a problem that they read a lot about in one of the books that's used in that Intro to Law course, we hope that we're trying to incorporate some of that learning. And so we take this problem from that book, some of you may be familiar with. I don't think I've said the Fearless Flounder Restaurant so many times. I mean, saying it so many times in the course was challenging. But anyway, they worked from that, and they wrote the answer in various different ways. So, it's lucky that I teach with Rosa because
No, that's the other.
I should have learned that from watching you. Okay, so, you know, they can write the basic question, and they can add these little add-ons that we've taught them. Add the facts, add, yeah, right. Well, you get the idea. They add,
arrow key.
pardon me?
The arrow key on the keyboard.
Oh, yeah. Oh. Plain and simple. Okay, so then they can add the jurisdiction under the Massachusetts law. They can add the rule, which states the applicable law, or they can write it in the simple version that we have here. And so we're just trying to reinforce the notion that this is an essential component. It can take different forms. The heart of it is simply stating what you were asked to answer. And by taking this approach, we're able to get them writing right away. They sit in that class, in the second class of the semester, and they're writing. They're writing something that they might write as a lawyer. And they're also being introduced to the concept that it isn't always going to be the same formula, the same format, the same style. It's going to vary. But this is an essential component that always has to be there. So that's pretty much our approach, and we try to keep that throughout the semester, taking up one building block after another. Some, of course, are more meaty than others and require a couple of classes, but by the end of the first half to two-thirds of the semester, we feel that we've introduced them to these essential blocks. And we still build our course around the formal office memo, as I think many of us still do. We practice, I mean, we teach in New York City, and maybe it's the urban employment environment, but our impression from talking to practitioners is, yes, the memo is dying, but no, it is not yet completely dead. And one of the impressions that I get is that some law firms still use the memo almost as a way of testing their students' ability to write. They assign them a memo over the summer kind of as a way of keeping them out of their hair. Go write this thing, and let's see what you produce. And then they use it as a way of testing to see whether they know how to write. They seem to still expect that students will be able to write one. When that message stops coming back from the field, so to speak, I'll be happy to stop teaching the formal office memo. In the meantime, I feel like we do need to teach it. And yet this approach is a way of sort of teaching it, but also teaching them at the same time that they can accomplish the same purpose in different forms of writing, as long as they make sure they've always included the essential building blocks. So, thank you very much.